Hi everyone, Tudor here from the Digital to Law team, and alongside with Paul, we're here today to discuss about your legal questions regarding running a startup. Digital to Law is a distributed law firm which is providing comprehensive legal services to digital entrepreneurs. And over the past 4 years, we've worked and discussed with over 250 entrepreneurs working on building their technology companies, either in the product or the services space. I've also tagged along Paul to have a little bit more of a hands-on deck to discuss different legal issues.
Hello everyone, I'm Paul. As Tudor mentioned, I'm a member of Digital to Law and I handle the data privacy and commercial and corporate issues. So I'll be here today to answer your questions regarding the commercial and the data privacy aspects.
Perfect. So I think we should get started and get going with the questions. First question. How do you go about setting up the legal framework for your startup in order to avoid the most common pitfalls? Well, I think you need to basically understand that when you're running a startup, you're basically building a company. So that eliminates from the get-go the idea of working as an individual. So you need to set up ideally a company. That means getting rid of the idea of setting up what's an authorized individual entity or a sole partnership entity, as it may be referred to in other countries. The best way to go forward is setting up a limited liability company, but there's one particular aspect that you need to take into account. The moment you should start setting up the company is the moment where you start to see some headway related to creating a product market fit. That may mean, for instance, you're either starting to sell the product that you're building, even if you're only selling to a limited number of users or customers at the beginning, or the fact that, for instance, you're raising an investment and that proves that you already have some traction, at least in the sense of an interest from the investor, and the investment needs to be raised using an entity. So it's usually a company, and especially in the Romanian space, it's a limited liability company. So I think that's the best way to approach it. And another important note is if you're doing it with other founders, so you're not a sole founder at the beginning, make sure you put down some objectives around running your business and the timeline to reach those objectives. The idea is, if from the get-go you decide you want to start a company and you're not necessarily sure about how things are going to happen, and you're not sure about each of your commitment or of your commitment or of your founder's commitment, you need to have some clear ideas about where you're heading to. And that's usually a moment where you need to put down some ideas about the objectives, about the key responsibilities of everyone in the team. And why not maybe even put those ideas into a shareholders agreement, and some of them are going to be reflected also in the articles of incorporation of the company. So that's just to give you a little bit of idea how to approach this subject. To sum up, I would do it not starting an entity before I achieve some sort of attraction, either validated by interest from investors or by getting at the point where I'm selling my product. And at the same time, prior to registering a company, or at the same time when you're registering a company, have a clear understanding of the objectives of each of the founders in the team, their responsibilities, the timelines that you're going to take in getting involved in the project. And very important, set some clear expectations about how the share capital is going to be split and why. That's really important because it saves you a lot of headache down the line when, let's say, in 6 months' time or 1 year's time, one of the founders is not really that engaged in running the business. and you need to have a clear understanding of and maybe a clear expectation of how that's going to unfold and how that is going to affect the share capital of the company. So understanding that some of the founders may exit the company sooner or later. Usually it's rather sooner, especially for very early stage companies, and have a clear idea of how you're going to operate with another founder exiting the company. So that would be in a nutshell some perspectives. Okay. Next question. What should a startup do to protect its IP? So I think there are two perspectives that you need to take into account at this moment. One is understanding what intellectual property is and what intellectual property you're creating in your company. And the other is understanding who is creating that intellectual property. And I'm going to start first with the first one. There are all sorts of intellectual property rights, which fall into place depending on the type of company you're running. Most frequently for software companies, we're talking about copyright, which is the type of right that is related to software products being developed. But it's also the case of trademarks. Whenever you want to register your name or your logo or a combination of the name and logos you're using to promote your business. And in case of more particular types of companies, let's say more where the technical nature of the product being built is more important, and that's usually the case for, let's say, health tech and hardware products in general. You may also be touching upon the aspects of patents. So it's really important to first identify the types of intellectual property that are relevant for the business that you're running. Again, it usually comes down to copyright, which is the most relevant type of intellectual property right when you're developing software. And the second aspect is related to who is creating those intellectual property rights. Under Romanian law, and again, also potentially applicable in other jurisdictions, the owner of intellectual property is the individual actually creating that asset, which is protected by intellectual property, let's say by copyright law. So in order for your company to be able to get ownership over that intellectual property right from the individual that created it, that right needs to be assigned by the individual to the company in order for the company to be able to consolidate its intellectual property portfolio and be attractive for investors wanting to invest in the company. So in order to do that, you must be aware of who is creating what in your company. The idea of assignment of intellectual property, assignment of copyright from the individual to the company is also applicable in the case of founders creating intellectual property. Let's say founders that are developing the software that you're going to sell or you're going to license. And that's really an important aspect, because when you're a founder, but you're also working on developing the product, you have two different, let's say, qualities, which you balance between. The one is the quality of founder shareholder, so the owner of the company. And the other is the founder who's also working as a part of the team developing the product. The simple fact that you're a shareholder of the company does not mean that the company owns the rights automatically over everything that you create. So again, in that context, if the founder is developing the software, he or she also needs to assign that the intellectual property rights over the software created to the company. And again, that replicates to designers, to people doing content marketing, to the people running your blog, if the case, because all of them are creating assets that are protected by intellectual property rights. Again, the people creating the website. So have a clear map of who's creating intellectual property, who's creating assets protected by intellectual property rights, what those assets are, and be sure that everything that is important for you in running the business gets consolidated, so gets assigned to the company, and the company becomes an owner of it. And make sure you think about that beforehand, because there's also people churn, human resources churn in startups. So you need to be aware that it's going to be much more difficult down the line to be able to assign intellectual property rights from someone who left the company, because they usually have no incentive to revisit the problem once they're gone, and that might make for let's say a more difficult conversation than normal. So map this out as soon as possible. Okay.
Okay, so I'll take the next question. What to look out for when signing partnerships, investors, collaborators, clients? Well, it depends on the type of agreement you have to sign. However, usually there are certain provisions that are generally applicable, and you should take into account a better assessment of such provisions. For example, you should always look out for the parties, and to make sure that the parties of the party with which you conclude the agreement has the right to sign the respective agreement. For example, if you conclude the agreement with a company, the person that has the representation power and has the power to sign the agreement is the director of the respective company. So you should make sure that the person signing the agreement is the director of the respective company. If the person is not the director, any other person within a company might sign an agreement only by using the power of attorney. So you should see if the respective person has such a power of attorney when signing the agreement. Otherwise, if the agreement is not signed by the person having the representation right, the agreement might be deemed null and void. So you can lose the entire agreement. Another aspect that you should take into account is the liability. You should always check the liability, your liability in the agreement. You might want to limit the respective liability. So, for example, you might want to include an amount, maximum amount, until which you are liable for executing the agreement. Third, it is very important to assess the termination of the agreement. You should always include in the agreement mechanism for getting out of the agreement. So you might want to include a unilateral termination clause and other termination provisions that that might ensure that you can get out of the agreement when you want to do so. Another very important aspect is the governing law and the jurisdiction. So, when signing agreements within Romanian territory with Romanian partners, the governing law, it's very easy to choose, should be Romanian. However, when you conclude an agreement with foreign partners, it might be the governing law, it might be a problem. So you should do your best to include the Romanian law as governing law, because this is a way to protect yourselves from foreign provisions that might be unknown to you. Another aspect relating to the governing law and the jurisdiction, is the courts competent to handle the dispute resolution. Lately, it's a fancy thing to include in any agreement a mechanism for handling the dispute resolution by going to arbitration. However, we always recommend to choose for the courts and not the arbitration, because the arbitration might be very expensive for you. So you should always choose the courts. In conclusion, these are the main provisions that you always check when signing an agreement. Like I said, depending on the type of the agreement, it might be certain provisions that you should also check, but this would be a complex and a long discussion. So yeah, I think these are all the provisions, general provisions. Yeah.
Cool. I think I'll take this one. What are the best practices for setting up a stock option plan for a startup? So first of all, depending on your jurisdiction, you need to see if there is any applicable legal framework regulating stock option plans. And if there isn't one, it doesn't mean that you cannot set up a stock option plan. As a general note, you need to know that if something is not forbidden explicitly in the law or is not particularly provisioned in a certain way, it does not mean that it cannot be done. So, for instance, in Romania, you have some provisions related to setting up stock option plans, but for public companies, that doesn't mean you cannot set them for private entities, so for startups which are not listed on the stock exchange or on other publicly tradable markets. For instance, in Romania, starting with last year, there have been some simplifications to procedures in assigning shares for third-party shareholders. So that makes it even easier, even for a company which is not raising investment, to create options. So let's say to create a mechanism by which shares in the company are being assigned, are being issued to employees or to collaborators or to advisors. You also need to take into account that most startups at the beginning are set up as limited liabilities companies, and under Romanian law, those can have up to a maximum of 50 shareholders. So if you come to a point where you're going to have more than 50 shareholders, you need to see exactly how you're going to structure assigning shares or granting shares to other people that you want to become shareholders in your company. And the way to structure it would be to see if you can set up an SPV which specifically holds shares for all the employees and all the collaborators who have access to shares in the company. And another really, really relevant aspect is the concept of vesting. Again, it's not per se regulated under Romanian law, but you can create a mechanism of deadlines and of conditions and criteria that needs to be met in order for the beneficiary of shares, so the employee or the collaborator, can gain access to those shares. So what you need to do before getting into the, let's say, the legal details of what I just talked about, is seeing exactly how much, and this is a business aspect, how much of your company you want to structure and you want to be able to allot to employees or collaborators in your company. And again, the dynamic may be different if you're a company that is bootstrapped and just wants to do that for its own employees, or a company that is raising an equity round and is going to be a company funded by investors, where in that context you may have some requirements from the investors to set up such an option pool, such a stock plan, because for startups that are getting investment, it's clear that the majority of the, let's say, the benefits of working for the startup come when the startup exits, so come as a result of the shares being sold, of the shares owned by the founders and employees and so on. So investors usually require you to set up such an option plan in order to incentivize and retain key employees, collaborators, and advisors that you need to help you grow your company. Those would be things in a nutshell. What I can tell you is that given the changes that have happened last year to Romanian company law, I think it's going to be far easier to assign shares or far easier to issue shares for employees and for collaborators in the coming future. There's been a lot of bureaucracy put to the side in the context of assigning or issuing shares to third parties. And I hope to see some boost in activity from that, and maybe even foreign entrepreneurs setting up companies in Romania, people from around Romania who maybe want to kick off a startup using other resources on the market, but also the legal framework currently standing. Okay.
Okay. How to best deal with data handling when you collect data for functional versus marketing communication. Okay, the best deal, the best way to deal with the data handling is to comply with the GDPR and any other data privacy legislation. For example, first and foremost, you have to inform the data subjects, meaning the persons whom you collect data from, about the processing of their personal data. In an online medium, you can do that by publishing a privacy policy on your website. And this privacy policy should contain all the mentions that GDPR provides for. For example, it should contain the identification details of the company. It should contain the purposes of the processing. Why are you collect the data from the personal data from your users, and what do you do with the respective data? It should contain the legal basis for the processing. For example, you might need the data for performing a contract or for sending marketing communication, and in such a case, when processing the data for marketing communication, you have to obtain the consent of the user for receiving such communications. Also, you have to, in a privacy policy, you have to indicate the duration of the processing, how long do you store the data, and you also have to indicate the rights of the data subjects in relation to their personal data, and the way a data subject can exercise his or her rights. All the information should be included in a document posted on your website, commonly known as the privacy policy of the website. As regards the collection of the data for functional versus marketing communication, the distinction is very important. When you collect data and when you collect and process data for functional activities, for example, you need the data in order to create an account on your website and to send an email to the user informing the user that the account has been created. In such a case, you do not need to obtain the data subject's consent, the user's consent, because the email and the username and so on necessary for creating the account and for sending the email are necessary. The data, the respective information is necessary for performing your agreement with the user. providing the services through your website. So you do not need to obtain his or her consent. However, in order to send marketing communications, you always have to obtain the prior consent of the user. So if you'd like to send newsletters or mail containing certain discounts or promotions that you might run on your website, before sending the respective marketing communications, you have to have the consent of the user. You might obtain the consent of the user via a checkbox that any user should might check in order agreeing that he or she wants to receive marketing communication. You should never send marketing communication without having the consent of the user. Another important aspect that you should take into account is that every marketing communication email or message should contain an unsubscribe button, giving the user the opportunity to unsubscribe from receiving such emails. So, in a nutshell, that would be the minimum necessary obligations that you should comply with.
Oh, okay. Maybe you could also take this.
Yeah. What happens when a founder leaves the company or she is no longer active? Oh, okay. That's a question that relates with the answer that Tudor provided to the first question. So it really depends. You might be lucky, and the breakup might be might be friendly and in good terms. However, it might be a difficult process, because when you found a company with a person and after a period of time the objectives become different, or I don't know, one of the shareholders wants something else for himself or herself, the breakup process might be difficult and might need a long negotiation and certain compensations for agreeing to the breakup. However, in order to best deal with such a situation is to handle the case in advance by signing a shareholders agreement, regulating all the situations related to the running the company, including the leave of one of the shareholders. For example, you can include in such an agreement, in a shareholders agreement, certain mechanisms regulating the leave of a shareholder. For example, by including a preemption right or a call option right, a compensation that the remaining shareholders might need to pay to the leaving shareholders, and so on. So the best way to deal with the leave of a shareholder is to conclude a shareholders agreement regulating the situation. So I think this is in a nutshell the best way to deal with such a case.
Yeah, so to sum up, I think it always makes sense to at least think about the legal issues you're going to run into, or you may run into, when you're starting a tech startup. Even if you don't have the time or the resources to solve them from the get-go, although that is, we encourage you to do that, it's also a good way, and it puts you in the top probably 10% of entrepreneurs that do that. it's a good idea to map the issues that you need to get solved, whether it's signing a shareholders agreement or getting your intellectual property in check and making sure that the company owns all the intellectual property it needs. Or if we're talking about having a template agreement that you're going to sign with the clients, at least list the things that you would need in order to be able to run a successful business. And once you get the time and the financial resources to do it, make sure you can and you start to do that and engage with a lawyer specialized in these ideas. And again, for instance, we often talk with the entrepreneurs about their legal issues, and we have conversations with them, even if we don't come to a conclusion that something needs to be done at that moment in time. But the fact that you discuss with someone who deals with that day in and day out might also provide you with some clarity. So have those difficult admin conversations from the start or as soon as possible. Paul, maybe if you want to add something as well.
Yeah, in relation to the to setting up a company and running a startup company, you should always be careful and make sure in advance that you can handle all the legal situations. Additionally, you should always check for ensuring that your commercial agreements, your intellectual property rights, and your data privacy related aspects are handled in the best way, in the best possible way. And maybe if there are certain aspects that you are not sure of what you should do, or that might imply a risk for your business, you should seek legal advice or consultancy advice from specialists.
Perfect. Thank you. It was fun, and we hope to do it again sometime soon.
Thank you.